Don't talk to him. Court calls the case People versus Thomas Steyer.
I'm Steyer, the living man. I'm here by special appearance to address this matter.
I'm sorry?
So I'm Thomas Steyer, the living man, not Thomas Ulrich Steyer, the entity you know me as, or as I'm on the papers.
All right, thank you. You wish to be represented by an...
No, I'm here to address the appropriate persona.
All right. I do have to advise, so you're going to represent, you need to stand in the middle of the podium where he's telling you to stand. Now, Mr. Allen. If you don't want to cooperate and handle things, he wanted you in the middle of the podium where you're supposed to be. If you don't want to be there, then say no. I'm telling you now to do it.
If you want me to stand close to the mic, no problem.
Sir, you want to play a game with me? No. Not today. Mr. Allen, take him. We'll bring him back.
Wow. Right from the start, you can see how this defendant has tried to play games with the court. Calling himself the living man is a classic sovereign citizen tactic, basically an attempt to separate themselves from their legal identity so they can dodge accountability. But notice the judge's patience here. He gives Steyer multiple chances to simply stand at the podium and cooperate, but when he refuses, he's escorted out. This shows how quickly these antics can derail a hearing.
On the Steyer matter, I sent my bailiff back to get him to bring him back out. The court is of the understanding that defendant, number one, is being, I will say, uncooperative, has purposely done some things to make it difficult to bring him out. What I'm going to do at this point in time, we're not going to wait and not going to play his game. We will hear him next week because of his behavior today before the court. At this point, I will revoke his bond and I will adjourn the probable cause conference. He certainly poses a risk to even bring him out. So I will adjourn this out to May 2nd, 2024. 9 a.m. or as the invite indicates. I will leave it there for the reasons that I've stated on the record.
This part is crucial. The judge isn't just annoyed. He's making a real decision with consequences. By revoking Steyer's bond, the court is signaling that defiance in courtroom has direct costs. You don't get to test the system and walk away. The system will always respond.
Day, the executor of the Tariq Maritari Kade Living Trust, and the registered owner of the Tariq Maritari Kade Ex Relatione Kindaman Wilson Estate.
You are appearing here without an attorney. I do have to advise you that you are charged with the offense of fleeing and eluding in the 3rd degree under the Motor Vehicle Code. That is a felony punishable by up to 5 years incarceration and or a $1,000 fine plus court costs. Additionally, the Secretary of State could suspend your driving privileges for up to a year. Do you understand that, sir?
I comprehend.
Do you understand? The court has to further advise you that if you wish to be represented by counsel, the court will ensure that counsel would be appointed to represent you in this matter and that you would have counsel if you could not afford to hire counsel yourself. I also wish to advise you that the court would be treating you the same as it would the people in this case. There are certain dangers to representing yourself in this matter, in that you will be required to abide by the Michigan court rules, the Michigan rules of evidence, and all of the cases and statutory requirements. You understand that?
I do not.
You do. What is it about that you do not understand?
It's against my religion to adhere or to assimilate to any statutory.
Sir, I'm not asking anything about your religion. It is irrelevant to me. I am indicating that in this proceeding, you will be required to abide by the rules of this court. Do you understand that?
I'm having a hard time understanding why or how religion doesn't play a role. How religion does not play a role.
Religion does not play a role in what I do or what this court does. There are certain rules of this established by the legislature and the Michigan Supreme Court regarding how these particular proceedings will be conducted. These proceedings will be conducted in accord with those rules. Do you understand that, sir?
To the American Declaration on the Rights of Indigenous Peoples, as well as the international or the United Nations Declaration on the Rights of Indigenous Peoples, the state and the governments should.
Sir, you have no authority for what you're about to state, because what you're about to state is.
Now we move to the second defendant, Tarek. His approach is a little different, but the strategy is the same. Reject the authority of the court by invoking religion and indigenous rights. The judge's response here is powerful. Religion does not play a role in what I do. That's such a clear reminder that a courtroom is governed by law, not personal beliefs. You can see the judge slowly losing patience as Tarek refuses to answer simple yes or no questions.
Well,
If you were on indigenous lands, if that's where you're going, then maybe you might be right. As it stands right now, this proceeding is not on indigenous land.
well, that's a matter of perspective, sir.
It is, and the only perspective that's going to matter on that is mine. We are not on indigenous lands subject to indigenous or tribal rules.
Is there a
You are
law?
subject to the rules of the Michigan Supreme Court as they are promulgated, both in terms of procedure and evidence. Do you understand that that's what's happening, sir?
I do not.
What is it that you do not understand?
I don't understand.
Because I'm going to tell you something, sir. If you are unable to establish or understand what and go through this with you again, I have to assume that there may be some reason why you don't understand. This court will take precautions to protect your rights, and I will be sending you for a competency evaluation to make sure that you are competent to stand trial and to stand in these proceedings.
So I would agree to a competency if the prosecution as well as the court and the officers agree to take a competency.
That's not the way it works. You don't get to make the rules.
I'm not.
I'm ordering a competency.
I'm not making.
Defendant is ordered for a forensic evaluation. I will set a competency hearing in this matter for July 25th, 2000.
Here's the breaking point. Because Tarek refuses to acknowledge the rules or even comprehend the process, the judge orders a competency evaluation. And this is interesting. Competency hearings aren't punishments, they're safeguards. The court has to ensure a defendant actually understand the process before moving forward. But in moments like this, you can feel the tension. Is this genuine confusion, or is it deliberate obstruction? That's what the evaluation will help answer.
You were supposed to file your motion with.
I did. I filed it.
When did you file it?
I brought it in.
Do we have it?
I gave it. I mean, it was stamped and everything. I gave it to the reception.
Why didn't you file it before today?
Well, as I stated at the last hearing,
No, don't go through what you stated at the last hearing.
Well, you
You
asked.
knew that, no, you knew it was supposed to be filed before the day. And you're going to figure out something. We're playing by my rules, not yours. So you know, do not say anything because you're going to figure that out real soon. Do they have it? They're sending in for a competency. I can't hear that. I can't hear his motion in any event. So I won't hear his motion at this time. He'll have to refile it timely if he's determined to be competent. So I'll have his bond.
This final exchange is honestly the most telling. The defendant tries to argue about when he filed a motion and the judge shuts it down with, "We're playing by my rules, not yours." That line perfectly sums up what these cases often come down to. No matter how many pseudo-legal phrases someone throws out, the courtroom operates under real law. And when defendants refuse to respect that, they only dig themselves deeper.